This is part 5 of civil procedures, looking at the pretrial setting. Pretrial mandatory disclosures. Initial disclosures include information of parties, names, addresses, telephone numbers, copy and or description of the documents and or tangible things to be used to support claims and or defenses, and a computation of damages. The use of expert testimony, including the identification of the expert, and they must produce an expert report for each expert witness. Prior to trial, the parties must disclose evidence the parties intend to present at trial other than for impeachment. Looking at depositions, a deposition can be oral, which is common, or written, which is rare. Oral depositions may be conducted on a party and or a non-party. These are conducted after an initial disclosure. To compel attendance of a party, only notice is necessary. To compel attendance of a non-party, that party must be served. Interrogatories, these are questions presented. You may present no more than 25 and only on another party. You may not submit interrogatories on witnesses. Interrogatories the answers to these questions must be signed by the person who makes the answers, and an attorney must sign any objections. Looking at physical and or mental exams, any party may request a physical and or mental exam, and a physical and or mental exam may be ordered by the court on motion by one of the parties if physical and or mental state is at issue in the controversy and there is good cause for the physical and or mental exam. Physical and or mental exam may be conducted by a suitably licensed certified examiner. It need not be a physician. Use of depositions at trial. Depositions are not automatically admissible at trial. The information in the deposition must comply with evidentiary rules. However, you may use a deposition against a witness where the deponent was the witness's officer, agent, and or proxy. You may use depositions for any purpose if the witness is either dead, more than 100 miles away, subject of illness, infirmity, and or imprisonment, or where you generally cannot produce witnesses' attendance by subpoena. So where the witness is unavailable, you may use their deposition for any purpose. Looking at interrogatories at trial, the answers to interrogatories are generally considered admissions and therefore can be used for any purpose. Looking at summary judgment. Summary judgment may be granted where the pleadings, discovery, disclosures, affidavits show no genuine dispute as to a material fact, and the movant is entitled to summary judgment as a matter of law. Now, the movant has a burden of persuasion. Now, this shifts to the non-movant the burden to produce evidence showing existence of a dispute. Summary judgment, motion for summary judgment may be made up to 30 days after close of discovery, and that completes part 5 of civil procedures.